Legal panel's here to weigh in. Amir Benno is a constitutional law attorney and analyst. Eric Schwartzreich is a criminal defense attorney. Welcome to you both. So we're talking about the United States versus scrutiny. It could ultimately decide whether states can ban these types of care, so-called care, for trans children and teenagers. The Tennessee law at the center of the case is one of a growing number of states' laws that essentially would ban these surgeries and hormones. And Amir, based on what you've seen so far, talk to me about maybe the points of strength for scrutiny and parts of weakness that you might have noted.
Great. Well, it's great to be here. So first of all, the question is, and we heard it in the soundbite before, this is a question of evolving medical standards. It's something that Chief Justice Roberts brought up at the oral argument yesterday. That is not something, if it's a policy discussion and how you, where medicine is at, it's not something that the court should be involved in. That's a policy issue that should be left to the political process, to the respective states to determine what's appropriate in their communities. On the flip side, you have precedent in cases like the Bostock case that came out in 2020 that says where you've got federal laws that discriminate or any laws that discriminate on the basis of sex, that those are unlawful. And they're saying in this sort of situation, you can't eliminate gender or sex from the equation. So this is, they're saying you're allowing certain people to get hormone therapy and puberty blockers if they're not using it because of gender dysphoria, but people who do have gender dysphoria, which they're saying is a sex-based condition, they're being discriminated against. So you have a constitutional question on one hand with precedent, and then you have the other side arguing that it's not constitutional at all and it's pure policy.
Yeah, but Eric, I think what really throws a wrench in terms of just the legal argument, feelings and opinions aside, I think that's the common sense argument plays well. But again, when you're arguing this, you have to look at the legality process. The term minor, when you add that in, you're talking about children. How does that alter the argument on gender-altering procedures?
Well, the issue is what scrutiny is going to be used. I mean, the question is that the justices are going to wrestle with, or what they're going to use to put the horse in the barn is this age discrimination, which requires a different level of scrutiny, because minors don't have the same level of scrutiny as you would on a sex-based type of claim. And is this a equal protection argument? Is this a claim that's based upon discrimination on someone's sex? And it looks like, because of the majority of the court and listening to the oral argument, that this is going to come down 6-3 with the conservative justices saying that, and I agree with Amir that this is better for the policymakers to make this decision. The law is not unconstitutional, should not require intermediate scrutiny or strict scrutiny, but perhaps a rational basis test, that this is not discrimination because it's age-based. And because it's age-based, I think the Supreme Court is going to put this horse in the barn and say that this law is constitutional and not strike down the Tennessee law.
Yeah. And also maybe, Amir, you could comment on that, right? Because, obviously you're not supposed to legally drink alcohol before you turn 21. And if a parent were to allow that or encourage that for a young minor child, wouldn't they face consequences? Is that also part of the state of Tennessee's argument?
It is. I mean, when we're talking about, you have to balance what the state's interest is here against all the other concerns. And one of the state's interests is protecting the welfare of minors. That's like you pointed out, Emma. It's a common sense thing that everybody understands that that's part of the prerogative of the state. It's also to safeguard the integrity of medical practice. That is another thing that the states have long been empowered to do. And so the state is arguing, look, these are well within the boundaries of what we're permitted to regulate, and that's what we're regulating. Nothing runs afoul of it, and therefore we should leave this to the democratic process, to the political process, and let the legislatures make the decision as what's appropriate in those given states.
All right. Again, as expected, a decision possibly by June from the Supreme Court. Amir Benno, Eric Schwartzreich, thank you both. We appreciate that.